Roman law, one of the most influential legal systems in the history of Western civilization, originated in the early days of Rome. The traditional founding date of Rome is 753 BCE, but the earliest known laws, the Law of the 12 Tables, were written in 451 to 450 BCE. This early code was a significant step towards a more structured and publicly accessible legal system. It aimed to create transparency and reduce the arbitrary decisions of magistrates, covering various aspects of daily life, such as property, family, and procedural law. During the Roman Republic, 509 to 27 BCE, Roman law evolved significantly. The Romans developed a more sophisticated legal system with the establishment of new legal institutions. Key to this period was the role of the praetor, a judicial official who had the power to issue edicts and interpret laws. The Praetorian edicts allowed for a flexible and adaptive legal system that could respond to new situations and societal changes. Moreover, the principle of jurisprudence, or legal science, began to take shape. Jurisprudence involved the analysis, interpretation, and systematization of the law by jurists, who were legal scholars and advisors. The works of these jurists, such as Gaius, greatly influenced the development of Roman law. The transition from republic to empire, marked by the rise of Augustus in 27 BCE, brought about significant changes in the administration of justice. Emperors began to exert more direct control over the legal system. During the Principate, 27 BCE to 84 CE, the emperor's edicts, decrees, and rescripts became primary sources of law. One of the most influential emperors in terms of legal reform was Hadrian, 117 to 138 CE, who commissioned the consolidation and systematization of the Praetorian edicts into a permanent body of law known as the Edictum Perpetuum. This helped standardize legal principles and practices throughout the empire. From the late 3rd century onwards, during the Dominate period, 284 to 476 CE, the complexity of Roman law continued to grow. Emperors such as Diocletian, 284 to 305 CE, and Constantine the Great, 306 to 337 CE, enacted numerous reforms. Diocletian, for example, issued the Codex Hermogenianus and Codex Gregorianus, which were collections of imperial constitutions. However, the most comprehensive and lasting contribution to Roman law came from Emperor Justinian I, 527 to 565 CE, in the Byzantine period. Justinian's Corpus Iuris Civilis, body of civil law, also known as the Justinian Code, was a monumental compilation of Roman law, which included the Codex Justinianus, a collection of imperial edicts, the Digesta or Pandecti, a compilation of writings of classical jurists, the Institutions, a legal textbook, and the Novelli, new laws enacted during Justinian's reign. This corpus served as the foundation of legal practice in the Byzantine Empire and later influenced the development of civil law in many European countries. The fall of the Western Roman Empire in 476 CE did not mark the end of Roman law. Its principles survived and were incorporated into the legal systems of the successor kingdoms. During the Middle Ages, Roman law was rediscovered and studied extensively in European universities, especially in Bologna, leading to the development of the Ius Commune, a common body of law that blended Roman law with local laws and customs. The influence of Roman law is evident in modern legal systems, particularly in the civil law tradition found in continental Europe, Latin America, and other parts of the world. Concepts such as contracts, torts, property rights, and legal procedures in contemporary legal systems can often be traced back to Roman law. Roman law's systematic and comprehensive nature, combined with its adaptability and rationality, has made it a lasting legacy that continues to shape the legal landscape globally.